Executive session?
Yes.
Okay. Cast your votes. And then all four of those items are moved to executive session, which puts us to item P, which is claims recommended for denial. Is there anyone here wishing to speak under any item listed under 8P?
Yes, and as Mr. Gross comes up, as you consider this claim, it's going to be on the Edgemere Park preservation. I would point out that we've written this as a conflict of facts, though based on the presentation and our memo, if you find the city employee has done anything negligent in damaging the sprinkler system when he was moving the snow, you can approve this claim. So it's really up to the council.
All right, and we welcome two-time Councilman Eric Gross to the chambers. Good morning, Eric.
Good morning, Mayor, members of the council. It's always a pleasure to be here. I want to introduce our current president of Edgemere Association, EPPI. We are, as you know, an historic preservation neighborhood situated between Walker and Robinson, between Northwest 36th and Northwest 30th. I've lived there since 1974. We're a very active neighborhood. We raise a lot of money. We spend a lot of money. We do a lot to keep up our parks, our medians. We even help support Edgemere School. We are here today to press our case for a $300 claim, and I'd like you to hear from our neighborhood president, and then I will wrap it up with some comments on the legalities of the situation. Also, Denise Waters is here to answer questions about the manner in which this case was handled by the city, and also has some photographs of the damage that was done, should you wish to see them. Alan Brown.
Thanks, Eric. Good morning.
Morning.
And I've lived in Edgemere Park since 1981, so it was 30 years this year. I'll just provide a few facts. I'd like to just give you some background information. Our Board of Trustees realizes a small amount, but it's kind of the precedent. As Eric said, we've done a lot of improvements in the public areas, the park and medians and other areas, right-of-ways. Most recently, we raised over $100,000, including some money from ODOT, to improve, make improvements in the park and the area at 36th and Robinson that's in question. And we have a agreement in place with ODOT to maintain that area, and we have a liability policy to, in case we cause damage. We also have an agreement with through Adopt a Park with the city to same type of agreement. In our opinion, releases the city from damage if we, cause some damage, but not the other way around. The city damaged the sprinkler system, and right now if the city doesn't pay for it, we're on the hook. We've already made the repairs. So we're requesting repayment of that amount. If the city, whoever caused the damage, doesn't pay it, we're kind of stuck with it. So we appreciate your consideration on that. Any questions?
Give me more specifics about what you believe happened.
Last February, a snow plow that was operating on that corner went over the curb and basically damaged the sprinkler system. Denise Waters could give you more detailed information, including photographs that she took. So, and that's been a while, and the claim, has been submitted for a while, but we made the repairs last spring.
All right. Tina, you want to tell us about the city on the side?
Probably have Denise Waters circulate these photographs, Mayor.
Okay. Hold on, Tina. Sorry. Tina, you want to come up and tell us about your work on this case?
Hi. Tina Hughes, I'm with the City Attorney's Office. This claim is for damage in a kind of a triangular median close to, on Northwest 36th Street, pretty close to I-235. My understanding is there's nothing in that medium grass. There are no beds right there. There is a bed there? Okay. Edgemere Park entered into agreements with Oklahoma City Beautiful and another one with ODOT. The real property where the sprinkler system is, in this case, the one that was injured, is the property of Oklahoma Department of Transportation, or the state of Oklahoma. We can confirm that we had a snow plow out there on February 1st, which would be about the right time. We would point out that there were 11.8 inches of snow that fell right around there, and I'm sure that the curb was not visible for the snow plow. We can't confirm whether that was done or not, and I don't believe they have a witness to whether that is what happened or not, although that's a reasonable assumption. So we wrote it up as a dispute of facts.
Okay, so Tina, from your point of view, there's just no proof that the city did it, but these pictures kind of lead us to believe whatever it is we think the pictures lead us to believe. Is that pretty much your point?
You can draw your own conclusions, yes.
Okay. Any comments or questions from council, from those that have seen the pictures? Gary?
Was this one sprinkler head?
Five. Chief.
Yeah, I think the legal question has to do, or some of the back and forth has to do with the contract with Oklahoma City Beautiful. And can you just elaborate on?
Yeah, there are actually two contracts covering this area. To begin at the beginning, of course, there's a lot to be said about the law. I can get to that, but unless I thought Dr. Shadid could move this to be approved, and I saw votes necessary to sustain that. But if I don't see that, then I've got to go through all this. ODOT gave us some money when they did the interchange at Northwest 36 and I-40. We had a dispute with them about how that interchange would be designed, and we resolved that. And they gave us $40,000 for landscaping, which we then used. If you're driving North Robinson and you get to Northwest 36 and you're going to turn to the left, you're going to see a lovely landscaped area. Well, we did that. We have a maintenance agreement with ODOT. We also have an agreement with Oklahoma City Beautiful, but that really doesn't control this case. Our agreement with ODOT provides that we will maintain the sprinkler system. Now, who owns the sprinkler system? Well, when this case first came up, that was my first question. In fact, I wrote a long email about it. I talked to Dan Brummett about it, then I sent a copy of the email to Dan Brummett and to my colleagues in the neighborhood, and here's what I concluded. The sprinkler system is affixed to the realty, so logically, it probably belongs to ODOT. But we have the contractual responsibility to maintain it. I therefore contend that we have a beneficial interest in that sprinkler system. It benefits our neighborhood, and we have a financial obligation toward it. If we have a beneficial interest in the property, then we have a right to make a claim for the damage to the property. So I don't have a whole lot of problems with standing here. With the issue, the legal issue of standing. I think we have standing to make the claim. The facts are not certain to the city. There was a snowstorm. The city does not know with precision the date upon which the snowplow came. I think that's admitted. What is certain is that the snowplow did the damage. You've seen the photographs of that. The city's memo, the memo from the municipal councilor, discusses negligence. I don't want to go into that in too many details, but the textbook definition of negligence has four aspects: duty, breach, cause, and damage. One of the first things you learn in law school. Duty, breach, cause, damage. In this case, obviously, the city has a duty not to damage or destroy other people's property. That's just a common law statutory duty. If the city does damage someone else's property, then that duty is breached. And if there's damage and the damage can be linked to the breach, there's causation, and so you have all four elements. The city cites a section of the Governmental Tort Claims Act, which of course is the statute under which this claim is filed, and the city contends, well, it's exempt in situations where snow or ice cause the loss, which reminds me of the old axiom in football, that the ground can't cause a fumble. Well, snow and ice can't cause a loss in and of itself, and in this case it was not the snow or the ice that caused the loss, it was the snowplow. Whoever was operating the snowplow wasn't careful, and therefore the damage was done. The city admittedly sees a conflict in the evidence, and that conflict in the evidence vests this council with discretion to do the right thing. Here's one other doctrine that applies, and that is the ancient common law doctrine of res ipsa loquitur. That means the thing speaks for itself, and res ipsa applies in situations where a party has the sole control of the instrumentality that does the damage, and where the damage is not ordinarily done without negligence. In this case, the city had sole control of the snowplow that did the damage. Sprinkler heads don't get cut off or damaged except when someone is negligent, unless it's done intentionally, and of course that's not the case here. Now, what should have happened here, quite frankly, is that when the damage was done, the city should have come to my neighborhood. It's not hard to figure out who's in charge, who's president, and said, we damaged your sprinkler and we want to fix it. That is the kind of partnership we expect to have with this city. The city encourages neighborhood associations such as mine. It encourages the kind of historical preservation zoning that we have. If the city damages someone else's property, it shouldn't take a process like this to make it right. The city should just stand up and say, we're going to send somebody out to fix it. And this is not the only claim. You'll be hearing another one involving mowing equipment and our lamp posts. But that will save that for another day. The council has discretion whether or not to approve this claim, and it seems to me that it's the right thing to do so. Alan and Denise and I should never have to spend our time to come down here and plead with the city, who we regard as our partner in developing and sustaining a great neighborhood, and plead for $300. I ask that you do the right thing. The city did the damage, and the city should pay for it. And the reason I'm here, incidentally, is because I'm concerned about the precedential value of this case. I don't want to see a public policy in the city where the city just says, well, we can do this kind of damage and make an excuse that it was the snow or the ice or something, and we can do that every winter, and whoever's responsible for the damaged property will just have to pay for it. Well, I mean, it's only $300, but at the same time, there's a principle involved here, and there's a precedent involved here. So we think the right thing to do is to pay the claim and admonish the people with the snowplows to be more careful in the future. Thank you.
I'm also concerned with the precedential value, and that's exactly why I wouldn't automatically just move this for approval and not have this discussion, because it goes beyond $300. It's the implications for the city. And we just debated in the last month a similar case where there was damage to a vehicle by what was presumed to be a garbage truck, but we're not sure. There were no witnesses, and in that case we voted against reimbursing the owner of that vehicle. So this is not being in a vacuum. There are other similar cases that have been debated here in recent past, and it goes beyond just $300. It's what is going to happen in the future when there's 1 foot of snow on the ground and you can't see the curb. I think the other issue, that we've discussed that hasn't been discussed today is the contract, which I don't think it applies, but there is language that absolves the city from any responsibility. Can you talk about, and that's the Oklahoma City Beautiful contract.
Okay. Yes, that's in the Oklahoma City Beautiful contract, and we took a second look at that. It was in the original memo, but we took another look at that, and by its terms, that only covers a flower bed.
Right.
So we excluded that as applying to this particular claim because this is outside the flower bed. This sprinkler system was really installed pursuant to their agreement with ODOT. And I agree with Mr. Groves that they do have standing to apply for a claim.
Okay. Well, I'm going to I'm going to move for approval. I mean, looking at the photograph, it does go over the curb by quite a bit, but I do appreciate the discussion, and I think it's worthy to have the discussion. And so I'm going to move for, how would I say this? I'm going to move.
Yeah, what we would do, we need to vote on the other items and then vote on that item separately.
Okay.
So why don't we first take a motion on item A, B, D, and E?
D and E have been deferred.
You're correct. D and E have been deferred. So we're really just voting on item 8A and 8P, 1A, and B first. So we have a motion and a second on that, and this is to deny those two claims. Cast your votes, and those claims are denied. Now, Ed, you want to make a motion on item 8P, 1C?
You just need to move to approve it.
So I want to move to approve it, which would result in the city reimbursing Edgemere Park $300.
Correct.
I move to approve.
All right. We have a second on that motion. All right.
Your Honor.
Yes.
May I ask a question, or a comment, really?
Okay.
And it's really Mr. Grove's comment that the person driving the snowplow wasn't careful. I find that hard for you to make that statement, not seeing the individual drive, and whether it's a matter of the ice entering into the fact that it slid up upon the grounds or some other reason. I don't know how you can make a statement that you believe the driver was not being careful in carrying out his duties.
It's an inference from the facts, Councilman. It's what we would infer, but...
Well, have you ever driven on icy roads?
Yes, sir.
Have you ever slipped? I mean, the vehicle that you're driving?
Yes, sir.
Would you say you were not being careful?
Depends on how fast I was going, but...
Well, I'm bringing up the same point. Unless you saw the individual and he was being careless, how could you make the statement that he wasn't being careful?
Because the damage speaks for itself. Because if you look at the photographs, you can see that it's way over the median. And I think the driver should know where the median is, in my opinion.
Possibly, but at 2 o'clock in the morning with limited visibility, with a foot of snow on the ground, it's difficult to ascertain whether he was negligent or not. We have very few instances where our drivers have actually
Your Honor, I think
it's possible he was negligent. It's possible that he was working with the conditions that were at hand. We really don't know the answer to that.
You know, a month or two ago, I can recall the exact date, we turned down a request for some payment because there was no definitive proof that the city did it. There were indications that the city did it. There was no definitive proof. Here we have nobody who actually saw the snowplow do this damage. And we're assuming that it did it, but a big truck driving over that median could have done a similar kind of damage. And then that's not unlikely given the conditions of the road and the snow on the ground. And I just have a problem of proving this based on the ones we've turned down that were similarly cited, and that there was nobody who actually saw the incident take place.
Okay. But as the memo points out, the city does recognize that its snowplow was in the area. I mean, if you read the legal memo prepared by the municipal councilor, there is all but an admission. I mean, as a lawyer, I would say that it is an admission that the city did the damage. The city's not sure exactly when it happened, but the city has, for all practical purposes, admitted the damage in its memo.
Eric, we had a similar case. There was a garbage truck in the area, and we turned it down. And there was the evidence there was no more convincing than what you're trying to provide here, or less convincing.
Well, let me add this, Councilman. You know, under the doctrine of res ipsa loquitur, the claimant doesn't have to prove negligence. All the claimant has to show is that the instrumentality that did the damage was in the sole control of the person claimed against, and that these things don't ordinarily happen without negligence.
And you can't do that.
Can't prove that it would not happen without negligence?
You can't prove that the city did it. Now, the assumption is the city did it because there was a city plow in the area, but there's no definitive proof that I've heard anyway that indicated the city actually did the damage.
We did not have a witness standing there at the time. We have witnesses who went there after the incident occurred, and we have an admission by the city that it was their snowplow. I think that's...
Their snowplow was in the area, not that it did the damage, I think. Yeah. And then, you know, there's no question that damage was done. I don't question that a bit. And there may be some basis pay that claim. But I think the conversation we're having here is sort of dangerous in terms of what we've done before. We've turned down claims with the same set of circumstances.
Well, the council will either pay for the damage it did or it won't. There's a right and wrong to this, very simple right and wrong.
When was the actual notice of this damage to anyone as it relates to the sprinkler systems? You say this was in February.
When did we file?
How much snow was on the ground on the alleged date that this was supposed to have happened?
Well, the staff memo says there was a lot of snow on the ground that day, but I'm not sure that was the day it happened. Now, Denise Waters is the most familiar with the facts of the case. Perhaps she knows. Do you know?
As to how much snow is there?
No, the day, exactly.
Well, why would a snowplow be out in the area if there's not a sizable amount of snow that would cause a snowplow to be out cleaning the streets anyway?
Well, what I can attest to is that I waited until the snow actually melted, because when the snowplow came through, they piled up additional snow from the road onto the area. And so it took several days for the snow to actually melt for me to notice the damage. And also, your comment about the truck, if a truck came by, if a truck came by and did the damage like that, it would be more of a compressed damage versus a scraped damage. That's my personal opinion. Yes. Yes. And
now,
so,
that was the comment I was going to make. Is to me, it's obvious in the pictures that that's a scrape. You can see where a grader has, because you can see the dirt has been thrown back up on the side. If it was just a truck running over the curb, you'd see wheel ruts. You wouldn't see that dirt thrown up there. You know, I don't.
Not necessarily.
To me, it's
with a foot of snow on the ground. I'm not sure that's true.
Your Honor,
yeah, David.
this is really towards Kenneth. Is the issue, because I'm just not sure that the city was negligent, but is that a requirement to approve the claim that we were negligent, or could it just been an accident and we're responsible?
No, we have to have been negligent. We do believe that this was done by the snowplow. That's why we make the statement in there, as Mr. Groves has pointed out. We do make the statement that it was likely done by the plow. As Councilman Mars has pointed out, this appears to be a scrape, and we know that a snowplow was plowing in the area. So we do have more evidence in this case than we do on the one that you turned down. Councilman, that's why we wrote it up as reasonable minds may differ on this, so there's a conflict in the evidence. But
and I would agree with the assessment that it appears that a snowplow did it. I'm not arguing that. I'm just asking the question. In my mind, I don't believe a person who the operator of the snowplow who went up a foot or so onto the ground that may have been covered by both snow and ice was negligent in operating that snowplow. Could he have made a mistake? Sure. And I guess it's coming from an accountant's perspective on what's negligence. If they perform it in a normal manner, using due professional care, not running into things that are certainly visible, like a parked vehicle or a person or a tree, if they ran into those kinds of things, sure, that's being negligent. But clearing the street and for the blade to go up a foot over the curb, I'm not so sure that constitutes being negligent.
Yeah,
in my
I think
opinion.
there is discretion on the council on that issue. Larry, you go ahead, Jimmy.
Yeah, I just have a question. Kenny, could you kind of give instructions to the jury here for me? If I don't think it was negligent, then I believe I should vote to deny the claim. If I think it's negligent, I think I should vote to approve the claim. Am I on the solid legal grounds with that assumption?
You're correct.
Okay. How about a motion?
Can I ask one question?
All right.
If, in fact, the memo has stated that a city plow truck, tractor, did the damage, then why is it on for denial?
The memo doesn't state that.
I thought this is what Kenny said.
No, the actual sentence in the memo is, City manager pointed it out to. Thank you. This was likely the cause of the damage. This is on page 2 of the
So our new standard is now, if it's likely that the city did the damage, we pay the claim.
Likely means more.
And that's my question. Don't tell me what likely means. If likely is the determination, that's a new standard, we have to approve the claim.
No, the question is whether or not you think the driver of the snowplow failed to exercise reasonable due care to avoid damaging the sprinkler system. That's the question.
But the basis of your question is that it was likely that the city was there.
Yes.
So our new standard is it likely the city was there, and did they exercise due diligence in performing their task?
Did they exercise due diligence in performing their task? Correct.
Okay. We have a motion from Ed to pay the claim. I'm waiting on a second or a new motion.
There is a second.
Who made the second? Okay, so we have a motion and a second to pay. Are we ready to vote? All right, so a yes vote pays the claim, a no vote denies the claim. Everybody clear? All right, cast your votes. And the claim will be paid 5-3.